morning. My name is Ron Moten, and I wanted to discuss the due diligence process, specifically due diligence prior to closing. I want to talk about a little background on due diligence, the definition. And the basic function of due diligence is to assess any potential risks, past, present, or the potential future that may occur with this new merger or acquisition you're about to undertake. It is a thorough process, and we'll get into the links and all that in a few minutes. Our objectives today will be to discuss the following: when due diligence begins, who conducts it. We will discuss the acquisition agreement, the duration, and key elements of the due diligence process, and some critical elements within those key processes, and also lawsuits, who may file and potentially what they will file for. In the early stages of due diligence, it begins with starting with available information, stuff that's available, in the public domain. You do your basic research, get a little information, and then that's when you move forward in the process if it's favorable. Generally, after that, what you'll do is you'll get into the due diligence process or the merger, and you'll get into pricing. Once you start getting into pricing, you start looking for the negative aspects of the company, because now you're serious. You don't want to just see the positive, you want to look at everything. When you do the due diligence process, the people who actually do the process are generally attorneys. These attorneys are outside attorneys who have a staff of professionals in certain areas as audit, your accounting, engineers. Depending on what your merger or acquisition is tailored to, they will get the subject matter experts in those fields to assist them in conducting the due diligence process. Now, the formal due diligence process begins when two significant events occur. First, when a confidentiality agreement is signed, and second, when a letter of intent is drafted. This lets everybody know we're serious and we're beginning the process. The next step in the main part of it is the acquisition agreement. Now, why you sign the confidentiality agreement and the letter of intent? The letter of intent is not a binding document. However, when you start to draft your acquisition agreement, this is a binding document. And this binding document plays a major role in the merger and acquisition process, as it's the roadmap that's set to guide you through the process. And there are specific elements in there which you will follow, and then there are some critical elements within those specific elements. Now, this acquisition agreement is generally drafted by the buyer. That's something you don't want to give up. You don't want to give up letting the seller draft the agreement. It's generally done by the buyer, and you don't want to relinquish that responsibility. Now, some of the goals for this document are: it sets forth a structure for the transaction. In other words, if you get into this merger, you want to use this roadmap or this structure to guide you through the whole process. As we'll find out, the process can be lengthy, or it could be speedy. It just depends. It also discloses important legal and financial information that you want to have out. That's part of the process. We want to get into the legal and financial aspects of this new acquisition or merger. It sets up conditions to both parties to track. Basically, what it does is it's a roadmap, but to get to that roadmap, it keeps you on track by setting up conditions to lead you toward completion of the process. You don't want to stall or get hung up on too many things, but it just lets you know this is the road we're following, and these are the objectives, and we want to get to this end state. It sets up what happens before and after closing should problems arise. So if something happens, the acquisition agreement will take you past closing so you can work out those issues. Now, as I said before, this process, depending on the company, any problems that that occur, could be between a few weeks and a year. Now, that's based on the complexities. If you're dealing with properties in different states, environmental issues, lawsuits, all these things have to, be dealt with prior to, if at all possible. So the process can be lengthy. Speedy due diligence is also, can happen also. What this does is ensures minimal disruption to the organization that's being acquired. It also reduces out-of-pocket expenses for all parties. It's a plus for both. So although you want to be thorough, if at all possible, if you can accelerate certain processes, focus on the important processes, it'll work out better for all parties. Some critical elements in the due diligence process are representations and warranties, covenants, and indemnity. Now, representations and warranties reflect the situation as of the signing date of the acquisition agreement. So everybody knows where we're at when we go into this. Covenants, it defines obligations of the parties with respect to signing and closing. The time between signing and closing, or it's covered under the covenants. So if anything occurs during that period, it needs to be brought up. And some of the things are material changes, things of that nature. Indemnity. Indemnity is this part of the acquisition agreement. It sets forth circumstances under which either party can claim damages against the other party. For example, if a material breach by the seller is made, you can use the indemnity to bring that up into you can use that to bring you can bring that up. Okay. Lawsuits. Lawsuits can and do occur during and after the due diligence process. Now, a lawsuit can be brought by certain parties. These parties have different reasons for filing a suit. I mean, a customer can bring a lawsuit based on a contract dispute, deceptive trade practices. Employees can bring suits, discrimination complaints, harassment lawsuits. Regulators, shareholders, suppliers, all these different parties can bring complaints up against the seller. These things need to be cleared up. You don't want to go into, or if you do go into this type of agreement, you want to know about these things ahead of time. Now, when we talk about some of these legal issues, this is another contention under indemnity. If there's a suit going on and it's not disclosed, that's one of the things that would be covered under indemnity. Now, in closing, we did discuss due diligence and when it begins, who conducts it. That would be the outside attorney, along with his professional staff, versed in their subject matter experts in various aspects of this process. We discussed the time limits, the length that could be involved, a few weeks to a year. We also discussed speedy due diligence. Now, you don't want to be speedy for the sake of being fast. You need to be thorough, in your due diligence. Acquisition agreements and its binding effects. The acquisition agreement is the roadmap, and it contains very important provisions within it to cover both parties. That is the heart of the process and needs special attention to detail on that, as it goes beyond the due diligence process and the closing. So it's very important. And we spoke about lawsuits. Lawsuits are an important part also because that's liability that you could be taken on if it's not, taken care of prior to closing. I thank you for your time, and I hope you understand the importance of due diligence, the due diligence process, significant parts of the due diligence process. I only highlighted a small part of it. There's much more involved, but I just want to give you an idea of, the importance of due diligence, some of the causes and effects, some of the things you need to be careful of, and I just hope you got something out of this. Thank you.